Welcome to our webinar on the Minnesota Cannabis licensing program that we are excited is just about ready to launch. So it's an exciting time here in Minnesota. We're excited to be helping our clients enter this new adult cannabis market. And we will be walking through the details of that program. Just so you know, we are a national cannabis law firm. This is all we do. Focus on this stuff every day. I am in Minneapolis. Yolanda is in Denver at the headquarters of the firm, and we have other offices scattered throughout the country. We've been doing this work for more than a decade, so happy to help our clients in Minnesota. That's us. All right, so first, let's do like a 30,000-foot overview. Tell you a little bit about how I came to be speaking to you today. I have been a lawyer for more than 20 years, primarily in Minnesota, primarily as a litigator in the construction space. In 2018, I began as a citizen lobbyist pushing for legalization here in Minnesota. In 2019, I became the Marijuana Policy Project lobbyist, and we actually got a hearing on a legalization bill in April 2019 that failed, but set the stage for where we are today. Minnesota, unlike a lot of states, is not a direct ballot initiative state. So we needed the electoral politics to line up to get the legalization bill passed. And of course, as you know, that happened. And Minnesota passed its legalization bill last year. It has been legal to possess and consume adult use cannabis for nearly a year now. But of course, there are no adult use cannabis businesses yet. And that is largely what we will be focusing on today, the rollout of our adult use cannabis program. And Minnesota is doing a lot of things very uniquely. We, of course, have a robust hemp-derived THC market that has existed since 2022, when we rolled out our edible cannabinoid product law, a phrase that rolls off the tongue. And as you also may know, that market has been largely, well, no license is required to sell products into that market, the hemp-derived THC market. That will be changing as the Office of Cannabis Management gets up and running and starts to require licenses for adult use cannabis businesses. We'll talk about this a little bit more later, but these hemp-derived THC businesses, manufacturers, and retailers will also need to be licensed under the umbrella of the Office of Cannabis Management beginning next year. So these are some of the high-level items we'll be discussing. Lots of changes to the licensing program. Kind of it was sort of changing minute by minute during the legislative session. So we hope to summarize things where they stand today, because Governor Walz did sign a bill last Friday that adopts some major changes that the legislature passed this past session. Okay, so I was doing some lobbying this past session for prospective social equity cultivators. And I was involved, of course, with other cannabis lobbyists who, when we heard that the Office of Cannabis Management wanted to move to a lottery, frankly, none of my clients were all that happy with that. The original bill provided for a merit-based licensing system where there would be scoring and points allocated to each of the applications. But now, of course, we are moving to a lottery. We began meeting with OCM and said, okay, if you're going to do a lottery, please make it a heavily vetted lottery. In fact, maybe consider having some capitalization requirements. And neither OCM nor the legislature was interested in that. So if you're wondering about that, don't think that at least some of us didn't try to get that into this bill. But it's a fairly low barrier of entry to enter the lottery through the social equity round that will be this year. There are some other major changes. There are now license caps imposed on certain license types, not all of them. Significantly, the micro businesses will be uncapped ultimately. We'll get into those details later. And it was interesting for me as a lobbyist who's been pushing for legalization the last few years and meeting with Republican legislators who really wanted nothing to do with cannabis legalization. But now that it's legal, many of them are very receptive to the business idea of launching cannabis businesses in their jurisdiction. So it was an interesting session for me because I had much more productive conversations with some Republican legislators than I had in the past. So, you know, the stigma is falling away. I think a lot of legislators, Republican, Democrat, whoever, recognize that this is a tremendous opportunity for Minnesota and for entrepreneurs like you. Okay, so we will start to dive into some of the takeaways from the OCM bill. So there are license caps for this upcoming lottery for social equity applicants that will be conducted this fall. But these caps you're looking at are for the entire program as a whole. So ultimately, these are the numbers of licenses that would be assigned to the social equity applicant category. And then additionally, there will be other licenses available to all applicants. So this is an and, in other words, 50 cultivator licenses total, 25 allocated for social equity applicants, 25 for all others. So I think it should be clear that placing a cap on these licenses more than likely will make them more valuable. Yolanda, what do you think about that?
Absolutely. I mean, when we go from a system that is completely open-ended, as it was in the initial iteration of the bill that was passed in 2023, to one that has, you know, not teeny tiny license caps, but definitely smaller than none. These licenses are going to be more valuable. You know, you're going to be competing against a far smaller market than you would have otherwise, which means each of the licenses issued will have a greater, you know, earning possibility. I also want to note on this state license cap portion of things that these are the state license caps in statute that are valid through July 1st of 2026. So after that point in time, OCM does have the ability, based on market demand and a market analysis, to potentially alter these state license caps. They do not have to, if you know, there are not enough qualified applicants that apply, they do not have to issue this full number of licenses. And while these 4 license types are probably going to be the most popular of the licenses available, all of the other license types, OCM does have the discretion to issue you know, they do not have to issue licenses. They can put in their own restrictions for an application period, which we'll talk about for the summer application period coming up here. So there really is some flexibility even within these license caps here.
Okay.
So yeah, so let's talk about this summer, because obviously I'm sure a lot of you on the line here are particularly interested in hearing what's going on. And this was a huge change. You know, the original bill did not provide a very concrete timeline here. And this new bill that was signed by the governor just last week includes very specific. We have actual dates here for the summer's application period, which is July 24th through August 12th. So it's a very short application window. You know, that's not even, I think, or just about 30 days. So that's definitely on the shorter end of what we generally see for an application period. They do have to provide notice 14 days beforehand. So we will be able to confirm that they're going to hit their statutory deadline by July 10th, which is, you know, will come up very, very quickly here. As we've mentioned, this summer is restricted solely to social equity applicants. This is intended to kind of provide a preliminary licensing period that will allow those who are selected in the lottery to kind of take the steps that they need to become operational and hit the ground running once the market officially opens. And we'll be talking about that a little bit more further on in the presentation. For this application period, there is a separate set of license caps. You see that on the side there. These are not overall state license caps that was on the previous slide. These are just what is going to be issued this summer. And by issued this summer, I mean, you have to apply this summer. We are anticipating the lottery will occur sometime in the fall. Given that the barriers to entry for this lottery are fairly low, we would anticipate that there are going to be a good number of applicants for each of these categories. Some obviously will be more popular than others. So it will depend on, the amount of staffing at OCM, which they are still in the process of staffing up, how long it's going to take to actually review all the applications, issue deficiencies, go through the whole process, and then ultimately hold that lottery again sometime in fall of 2024. I would anticipate October at the very earliest, but it could very well be later than that, and it will largely be dependent on the number of applications ultimately submitted. One thing to keep in mind is that this is a statewide lottery, so there are no regions that you have to select for where you're going to locate your business or anything like that. This is just kind of broad-based all across the state.
Yeah, so like I said, a lot of my clients, frankly, were gearing up for the merit-based licensing system, and a lot of them would have preferred that. In all candor, though, I see, I guess, the wisdom in what OCM's trying to accomplish here. I think it's fair to say that other states, as they've rolled out their adult use cannabis programs, they've tried to get social equity right. I think it's also fair to say that none of them really got it quite right. And I think our OCM recognizes that awarding these provisional licenses to social equity applicants early gives them the chance then to go out and try to raise capital based on the fact that they've been awarded a license. And then they can go secure a property, whether it be purchasing property or leasing property. So I see what they're trying to do here, because I think in other states, we've seen the challenges in just handing a license to a social equity applicant, and then, expecting them to sort of have all the capital on hand. So I see what they're trying to accomplish here. I certainly wish them the best. I hope this succeeds. One other thing I'll point out here, the application period indicates it's starting July 24th. The legislation indicates that OCM must start the application period no later than July 24th. So it's possible it'll be earlier, but I think it's fair to say OCM might need all the time it can get to get ready for this. And it's interesting that, like Yolanda said, there's no real geographic component to this licensing process. So it'll be interesting to see how OCM enters people into this market without factoring that into consideration.
And I think something that is kind of underpinning this entire conversation that we are having right now is all of our conversation today is based on the two statutes that we have. We do not yet have the regulations from OCM. They have not yet issued any actual application materials. So all we have to go on right now is the statute, which is robust, and we have lots and lots of information, but there is still more information to come. And OCM will be putting out additional guidance, forms, information regarding not only this summer's application period, but also as the program progresses, subsequent application periods, additional ownership restrictions, things of that nature. So it's very important to continue to stay in the loop on this stuff.
Okay, moving on. So yes, among the other substantial changes to our licensing program, in addition to adding license caps and adding a lottery, are pretty substantial changes to the social equity criteria. As you can see, all military veterans would now qualify for social equity. So that is going to add, I think 6% of the Minnesota population now would qualify for social equity status based on this. It was a little unclear in the original version of the legalization bill of whether it did apply to all military veterans. Now it's very clear. Any military veteran would qualify. These criteria we're identifying here are in addition to the social equity classifications that exist in the original legalization bill. So they're adding these criteria. They've added additional sort of low-income neighborhood criteria. You may have seen some local media coverage trying to identify on a map where those neighborhoods may be. We're hoping that OCM will issue its own map, so it's not a matter of guesswork to know whether if you live in a particular area, you would qualify for social equity or not. We as a law firm are also sort of crunching that data to try to come up with our own maps, but just know that more information is coming on that. They have also tweaked the emerging farmer definition. If you're here in Minnesota, you may have followed the lawsuit that is targeting that emerging farmer program, which is on the books as an agricultural program here, challenging it as unconstitutional. So we're moving away from the prior definition and toward a definition that, you know, essentially is for a low income farmer. So again, more ways to qualify here. And I think one thing to be aware of, we will obviously, you know, as a law firm working for our clients, we are going to comply with the law. But there are ways to get creative here. I mean, there are features of these social equity criteria that may allow both you and some family members to apply, particularly if you have a cannabis conviction in your past. So happy to talk further about those things with you if you wish.
Yeah, one thing I would add here as well is, especially in regards to the low income criteria, is residency. So residency is not a requirement for this social equity criteria or to otherwise be eligible for licensure in Minnesota. However, it can be helpful, right? So as we're talking about here, these low income areas, this is percentages of, you know, individuals who might be receiving SNAP benefits or who are within certain percentages of the poverty line. In order to satisfy that criteria, you have to have resided there for the last 5 years before you apply. For the emerging farmer, there's also a 3-year, you have to have been a farmer for 3 years. So there are some longer term areas to keep in mind. It's not simply that you ever, you know, worked on a farm. So there is a little bit more to it. In regards to the convictions, it's also important to keep in mind that these are certain convictions that will allow you to achieve certain social equity status. And it isn't necessarily you yourself. This was an existing definition, but they have retained it through the new law. So this is for yourself. It can be certain parents or guardians, dependents. If any of those individuals in your immediate familial network received certain cannabis related convictions, you may be eligible for social equity status. I will also say that there are many, many ways to determine social equity status, and each state that has done a social equity focused licensing round or issues social equity licenses generally for cannabis takes a different approach. In some states, it's based on kind of more racial or ethnic background. Some states, you know, women-owned businesses or minority-owned businesses might be qualifiers. But here in Minnesota, these are how they have defined it. And it's just a policy position from the state for how they're defining social equity. So now we get to talk about the fun stuff, is like, what is the application process when we're talking about summer 2024? So as Jason's alluded to, this will be a qualified lottery. And what that means is, as opposed to submitting an application that the OCM is then going to review and score and rank against your competition, it is a minimum qualified lottery. So that what that means is they're going to go through, they're going to make sure that you submitted everything that you needed to submit. They're going to make sure that all of those components that you did submit satisfy their minimum criteria. They are going to be issuing what that criteria is that they're going to use, so that applicants are aware. We do not have that information quite yet, but it will be forthcoming. And so long as you hit those minimum requirements and are not otherwise, you know, ineligible for licensure, you are going to be entered into the lottery. So again, this is a much lower barrier to entry. You don't have to have X number of dollars sitting in a bank account. You do not need to have property which is another huge component, which was a big change as well, because originally you did have to have a property to apply. You do not now. So you can just go in. We'll talk a little bit more in detail about what specifically is needed in this application, but it's much more narrative heavy. It's more just general business information as opposed to some of these other higher barriers to entry. They will be providing, as they're going through this review period, once applications are submitted, there will be what's called a 14-day deficiency period. So if OCM identifies something that is not quite up to snuff or something seems to be missing, they will actually reach out to the applicants to let them know, hey, we need X, Y, or Z. You'll have 14 days to respond, assuming that you do respond in a timely manner and adequately, satisfy whatever the deficiency that they noted is, you can still be entered into the lottery. If you do not respond within their timeline or do not provide what they're asking for, you would then be disqualified from the lottery. Another important thing to note is the lotteries are only actually going to be held if there are more qualified applicants than available licensing. So you'll think back to the slides a couple of bit ago. This summer, there are certain license caps that are going to be issued, again, different from the state license caps. But if there are, for instance, only 20 applicants for the 50 available testing laboratory licenses, they will not need to hold a lottery. Anyone who in that case was qualified would receive that preliminary license. Another important thing to note is that if you do submit an application for this round and do not have your application drawn in the lottery, so you are not one of the winners of this summer, you can have your application retained free of charge for an entire year after you submit for any subsequent licensing rounds that would occur. Again, I want to reiterate that the licenses available this summer are only social equity and do not hit the maximum number of license caps. So that means that there are going to be at least one, if not two more lotteries, probably over 2025 that you could then be entered into. I do see in the chat that no, application fees are non-refundable. So this is, probably an expensive lottery ticket, more than, the one that you might get at your corner convenience store. Obviously the reward is also, well, I guess depending on how you look at it, could be greater or not. I don't know, some of those super mega millions coming out lately would probably be great, but you do have the ability, and if you do choose to keep your application retained, you would not then need to pay an additional application fee. So that is a benefit of keeping the license retained.
So Yolanda mentioned if there are not enough applications received in excess of the cap, they won't do a lottery. And of course, next year when they're issuing micro business licenses to the broader public, again, there is no cap ultimately for micro businesses. So that round next year will not be a lottery. It will be, I suppose, a form of the merit-based system where they're going to just be looking at whether you meet the criteria.
Yeah. Though they could, just like they did for this summer, they could choose to say that they're only going to issue X number of licenses in that application round. So it really just does depend ultimately on how they choose to put that application period forward and how, what the ultimate adult use regulations look like once those are published.
Yeah.
And
And just one other point before we move on, a lot of people are saying, well, are they going to do all the lotteries for the social equity applicants at the same time? Are they going to do it sort of on a rolling basis? I mean, we just don't know yet. This is all very new. I think we'll be getting that information within the next weeks, hopefully.
Yeah. And I will say too, for better or for worse, things can change. Once they do this initial round, they might choose, as Jason mentioned, to do things kind of on a rolling basis, cultivation, then manufacturing, then retail. They could do everything at once. They may pick one lane and choose to alter it as they've done for the statute itself. So this is a quickly evolving industry, and it's just important if you're interested in getting engaged, that you remain engaged because things can change very quickly.
Okay, so in terms of this year's licensing round, like we said, these are, we're calling them licenses. OCM might be getting mad at us because it's technically a provisional authorization they'll be giving this year. It wouldn't become an operational license necessarily until they're finished with the rules and regulations that we expect to be done Q1 2025. And then the provisional licenses, or provisional, whatever they're called, that you get this year would become operational with an exception. So I was lobbying for some prospective social equity cultivators. My one job was to see if I could get early start cultivation. And hey, I succeeded. Thank you, Senator Port, to that. Senator Port identified early cultivation as mission critical. And we are allowing so if you are awarded one of these provisional things this fall, and it has a cultivation component to it, you can make that aspect of your license operational immediately. So we're talking cultivator license, micro business, meso business. Micro and meso, those are the two vertically integrated license types, and they have a cultivation component. So they could make those cultivation aspects operational effective immediately. The recently passed legislation says so long as you comply with the current Minnesota medical cannabis rules as it relates to cultivation, then those are the rules you'll be abiding by. And then ultimately, after OCM passes, the broader range of rules and regulations that are going to guide its overview of this industry, you'll be complying with the OCM rules. You do need to make the components of your license operational within 18 months. Otherwise, it's a use it or lose it type thing. So let's say you have a meso business license that you've received, and you've only made the cultivation and manufacturing components operational within 18 months, but you don't have a retail location yet, that it's possible that will revert back to OCM. So that's a way I think OCM is, or a tool I think OCM is employing to make sure people just don't get these licenses and sit on them without doing anything with them. We need a robust market. We need an industry, actual functioning industry. We need product moving through the pipeline. So that's a way for them to sort of manage that.
Yeah. And I will say a couple other points on this slide here. So this 18-month period to become operational, this is not totally unusual. Again, this is borne out, as Jason mentioned, so people don't sit on the licenses or receive a license and then immediately flip it without actually making it operational. You will have an opportunity, and this is not solely just for the licenses that are issued this summer, but this will be also in place for any subsequent licensing period. You'll have 18 months to get that going. There are options to request an extension for this. So you can request for OCM as long as you've made good faith efforts to operationalize. Things happen, construction delays, delays in local approvals. Hopefully we won't see another global pandemic, but that certainly impacted those state markets that were getting up and running at that time. So there is a little bit of wiggle room, but you do need to make efforts to become operational. And what that means really is you have to find a location that the OCM then confirms is compliant and approved. You have to work through whatever the local process is, and that's just in regards to building, construction, zoning, those kinds of things. You'll also need to provide to OCM if you have had any updates. You do have a continuing disclosure for both ownership, true parties of interest, finances, which we'll talk about in a little bit here, that will continue to need to be updated with OCM. And then you'll have to actually have a final inspection by OCM to make sure that your facility is up to standards and compliant with all of the laws and regulations. Cultivators, even though they are going to be able to get started earlier, will also still have to provide their location to OCM. There are some steps still, but they will be able to start their actual licensed cannabis activities far earlier than any of the other license types.
So if you're paying attention, you may be asking yourself, well, okay, let's say I'm an early start cultivator and I'm harvesting my first crop. Where am I going to sell this stuff? And there is no clear answer to that right now. The early start cultivation component was introduced very late in the legislative session, and there were efforts to allow these early start cultivators to sell cannabis flower, et cetera, in our existing medical cannabis dispensary network. Those were not approved. So it remains to be seen, I guess, what happens when there's product that's been cultivated and there's no clear answer as to where it's going to be sold. I don't really know what we're going to do about that, other than that many of our tribal nations, as you know, have active adult use cannabis businesses on tribal land, and there may be some movement on the compacting process between some of those tribal nations in the state of Minnesota that might allow some of our Minnesota tribes to start opening dispensaries off tribal land. I don't know. This is all just pure conjecture. And it may be that the legislature needs to come back. They come back into session in January. They might have to find a solution to this, because OCM has been doing what it can, but there have been some delays. And I think even though they're projecting rules and regs to be done Q1 2025, it could get delayed, and there could be a delay with that licensing process. So we'll see. This is a stay tuned kind of thing.
All right, so now let's get into what is the actual application that you need to submit. If you, hit your social equity status, you will need to provide documentation to prove that you are actually a social equity applicant. And that means that 65% of your entity is owned and controlled by those social equity individual or individuals. You can't have a group of individuals that make up that social equity if you have like a group of veterans or what have you. But they need to maintain that 65%. And if you have a social equity license, you cannot transfer or sell that license to a non-social equity group for at least 3 years from the date of issuance. So again, just like you can't get a license and immediately flip it if you don't make it operational, you can't receive a social equity license and then immediately sell it. You have to hold on and operate that license for at least 3 years. Otherwise, in terms of what else is required for the application itself, as we've mentioned, you do not need to have property, which is a pretty big change. Obviously, it costs a good bit of money to secure a property and get that initial lease in place, or obviously if you're purchasing, even more so. So that is a nice way to expand the pool for those who are going to be available to apply. Otherwise, it's largely written and narrative based. So you have to have an employee training plan. This was previously an optional submission item. It's now required. There's also certain SOPs or standard operating procedures that are required. We have those listed out here. That's quality assurance, inventory control, storage and diversion, accounting and tax, fairly usual what we would expect to see. For the narrative side of things, there's also going to be a security plan, a business plan, a kind of operational plan based on your license type. So if you're in cultivation, you'll need to provide a cultivation plan, processing, a processing plan, retail, a retail plan. If you have one of the vertically integrated license types, so a micro or meso license, you would need to provide all 3 of those. So just something to keep in mind. That's probably one of the larger lists, is those narratives. But again, this is meets the minimum requirements. So you are just writing to the statute, since we don't have regulations at this point in time. They have another change that they made is to fairly significantly expand the disclosure requirements. So in addition to the normal, corporate contact information and just general corporate information, you do need to have owners over 10% will need to be disclosed. True parties of interest will need to be disclosed. Financiers will need to be disclosed. We're going to talk about these in detail a slide or 2 from now. But it is a little bit more intensive than it was previously. We also need background check releases from anyone who's featured on the application to just authorize OCM to run criminal background checks on everyone to make sure everything is above board and there is no disqualifying offenses present. One last kind of interesting aspect of the Minnesota application is you also have to have an attestation from a bona fide labor organization stating that the applicant entity has entered into a labor peace agreement. So this is basically an agreement with a union in the state that serves cannabis businesses, saying that you will allow them to, you know, do their union activities without fear of reprisal, essentially. The big ones in Minnesota and for cannabis broadly are the UFCW, and Teamsters is also kind of getting into play. When an application is submitted to OCM, there will be a review period by OCM. It's not like you can put anything in particular in there and then you're automatically entered. There are minimum standards. We will be getting additional information. Jason, if you can just go back one slide.
All right.
All good. We are going to be getting additional information from OCM on the criteria that they're going to use for these minimum qualifications. And that's specifically for these categories: security and record keeping, employee training, the business plan and financials, labor and employment, knowledge and experience. So that is the kind of knowledge and experience of the owners of the entity, as well as an environmental plan, which is part of the business plan. So again, we will be getting additional information as to what specifically OCM is looking for. At this point in time, it should just be qualifying criteria that is released. But I will say we have seen some states actually go ahead. We saw this recently in Maryland, where they actually released a state template that had to be used for the narratives themselves. We're not anticipating that here, but it is something to keep in mind that the state does have broad discretion to how they want this to look within the confines of the statute. Okay, and now you can go to that next slide, Jason. So you can still have your application denied if it's incomplete, if there are false statements, if your application team does not meet the ownership qualification. So if you have a disqualifying offense, or if you are 18 years old, you are ineligible to be a licensee under the cannabis program. You see there's several things. You didn't pay the application fee. You submitted more than one application for a type of license. You didn't submit by the deadline. I know that sounds silly, but you would be shocked at the number of people that try and submit after the deadline. And it is, they take these things very seriously. And you will get bumped. Like, people do get disqualified from these things. So although they have made it easier, that doesn't mean that you should rest on your laurels. You do still need to be very much paying attention and making sure that you are on top of things. I see that there is a question here about what's the timeline to get started on this. As we mentioned, we are anticipating that the application window will open July 24th and close August 12th. It is the end of May, so I would recommend getting started right away on this. There's more than enough time to get it done, but that time will go fairly quickly. And while this is not the most onerous application, there are a number of components that you'll need to work through.
So like Yolanda alluded to earlier, we have one of the other major changes is this addition of a true party of interest definition to the statute. So I think this is a recognition by the legislature of what's happened in other markets where one applicant might assemble, dozens of people essentially that they're ostensibly indicating will be running the company. And we're trying to avoid that issue where a straw man or someone's just simply packing the lottery with as many lottery balls as possible, because we don't want to give them an unfair advantage in controlling the market. The emphasis, I think, by the legislature through the passage of this bill has been to try to create a craft cannabis market. And I think if it was the state legislator speaking, they would say a Minnesota first craft cannabis market. Obviously, you cannot restrict it to only Minnesotans. That would be unconstitutional, of course, but that I think is their emphasis. So I think my one experience with lottery packing happened in the South Dakota medical cannabis market. There was one group in particular that seemed to obtain more ping pong balls than others, and now that entity controls roughly 50% of the market down there. So I think that's what Minnesota's trying to avoid here, trying to give a fair shot to everybody. So this true party of interest idea aims to ferret out that the applicant is truly the person or the entity that's going to be running the business, that they're sharing in the revenue, and trying to discourage these side agreements, these management agreements that might be erected over maybe perhaps multiple applicants, showing some sort of coordinated effort. But there are, of course, limits, I guess, to even this idea. You need to be at least a 10% owner to be forced to disclose your identity here. So I suppose you could own 9% of just about every license in the state if you wanted to under this idea. But remember that at least for the social equity criteria, that applicant, that owner needs to own at least 65% of the entity. So that, in a nutshell, is what Minnesota is trying to do. Yolanda, do you want to speak more to the financier idea?
Yeah, and a couple things. I see one question here, so I do want to just clarify. For social equity, it's not the staff, although obviously I think that would be encouraged if your staff was, largely social equity focused. It's ownership and control. And this is where, it does, it may be to some of y'all's benefit to speak to a professional about this, because it can become a little bit complicated with who's owning it, who's actually controlling it, where is the money going? And that's what the state is going to be looking at to determine that 65%. And that's also what they're going to be looking at as we get into these true parties of interests and the financiers. So basically, these financiers are not like your non-traditional lending sources, which is what largely cannabis businesses are going to be using. So as a cannabis business or a hopeful cannabis business, you are not eligible due to the federal status of cannabis to go to your local neighborhood bank and ask for a small business loan. They just will not issue them to cannabis businesses given the federal status. So that means most of the financing for cannabis businesses is private investment. So this is a way to make sure that the state, from the state's perspective, so that the state knows where this money is coming from, and essentially that everything is above board in the operations. So they do need to be disclosed on the application. And they're going to want to look at, the specifics of the agreement to make sure, again, when we talk about that social equity, that the financier is not receiving the majority financial benefit of the license, but that it is genuinely the owner and the social equity individual or individuals who are receiving the benefit of this license. Okay. In regards to local governments, so I've mentioned that you don't need to have a property to apply. However, as I'm sure all of you guys are picking up on, you need a property in order to operate. Your license will be tied to a specific property. So the government, your localities do have a role in this process. But it is a slightly different role than they had previously. So in the original iteration, local governments were actually going to be sent a copy of your entire application and asked to provide written feedback to OCM to determine if the license should be issued. They now have a much smaller role to simply confirm the local zoning and land use compliance. So they retain the ability, just as they do for any other industry, to put in place what are called time, manner, place restrictions. So that's saying that, cultivation, we often see in agricultural zones, while a retail facility is usually in a commercial zone. It might be inappropriate to have a manufacturing facility in a commercial zone, given the other uses in the area. So local governments can still put that into place. And all businesses do need to make sure that they're aware of what the restrictions for the local governments where they hope to locate are, so that when you're selecting the property, you make sure it's compliant and you can use it for what you want to do. Local governments also have the ability to put setbacks into place, which are very important to pay attention to if they are put into place, because that can be 1,000 feet from schools or 500 feet from daycares, public parks, rehab facilities, things of that nature, which can greatly minimize the number of available properties in a specific location. So
Yeah.
again, just something to keep in mind.
Yolanda, can I jump in? So
Yeah,
one,
please.
one other wrinkle here is that there are certain local governments that have enacted moratoriums on cannabis businesses. Under the state law, those moratoriums need to sunset as of January 1, 2025. But now we have this unique situation where with these early start cultivators, well, that certainly is a cannabis business. And so you need to be, if you're planning on being one of those early start cultivators, perhaps look at whether there's a local moratorium in place, because those can legally remain on the books for at least through the end of the year.
Yeah, and something important to note too, you'll see that there's this gap between the application period and January 1, 2025. Localities have until the end of 2024 to put ordinances into place. And they can always have the ability to put time, manner, place restrictions into place, just like the government has the ability to change the statute or the regulations. So again, it's important to make sure that you're in communication with the locality that you're hoping to locate in so that you know what's going on, you know if the city council is planning on bringing this up, if they're very friendly and want cannabis businesses in the area, or if they're very opposed and are going to make your life as a business owner a bit more onerous. Again, just something to keep in mind. One last note on local governments is municipal cannabis stores are permitted. We now know that they will not count against the number of licenses that are available in a specific license period or other local limitations that may be put into place at the local level for the number of licenses that can be had in a certain municipality. But that's something to know. So if there are definitely municipalities that are considering opening their own cannabis store, just like they may have their own like liquor store. But as you're doing your market analysis, that could be something that you want to consider as well.
Okay, so it wasn't just adult use cannabis that was addressed in the recent legislation. Many of those provisions also address our hemp-derived THC market. So when I was lobbying in favor of the edible cannabinoid product law back in 2022, I did not anticipate the explosion of our hemp beverage market, but it's been wonderful to watch. And of course, it's not limited to just Minnesota. That sort of experiment is spreading elsewhere. And we are making changes to our program here as well. Once licenses are required for these hemp-derived products, they will no longer be called edible cannabinoid products. They'll be called low-potency hemp edibles. And if you're a manufacturer or a retailer of those products, you will actually need to get a license from OCM to continue working in that space. But if you are registered with the Minnesota Department of Health as an entity manufacturing or selling those products, we understand that you will simply be converted to a license automatically. You could, of course, apply for a license, and as there is no cap on those licenses, and the cost is relatively low. Other changes here, amazingly, beautifully, hemp-derived THC beverages will soon be available on tap. So until July 1, 2024, those are, even if you went to a bar or a restaurant, you had to be served a hemp-derived THC beverage in a container, but that will change soon. And the 5-hour rule that was on the books, which would have prohibited a server from selling a hemp-derived THC beverage to someone who had consumed alcohol within the last 5 hours, that is off the books now. And the rule is you simply may not serve those hemp-derived THC beverages to someone who's obviously intoxicated. So much easier to enforce, and it tracks with sort of our alcohol laws. The designer cannabinoids are back in the hemp space. So CBG, CBN, those are back. Tinctures are now expressly allowed. And there is a bit of confusion about the applicability of those labor peace agreements that Yolanda referenced. that requirement only applies to adult use cannabis businesses and not to these hemp-derived THC businesses. So I understand there might be a union sort of knocking on the doors of some microbreweries around town, but that requirement is not applicable to that space.
Yeah, one last thing on the labor piece, just because I didn't mention it earlier. Also not applicable for micro businesses in the adult use cannabis space if you have fewer than 10 employees. Very, very nuanced and niche there, but just wanted to throw that out as well.
Yeah,
And I know we're
that was the last thing, but I do have one more. So plug the Hemp Beverage Alliance, a community of 200 plus hemp-derived THC beverage companies from across the country, is holding their first ever conference and festival in Minneapolis the first week of June. So let me know if you're interested. We can set you up with ways to register for that.
Yeah,
it'll be held at Minneapolis. The festival will be at Minneapolis Cider Company on June 8th.
yeah. I think some of our staff members and attorneys will be present at that as well. So would love to meet you if you're there.
Excellent.
I know we're coming down to the end of our time here. We have a few more slides, so I'll go briefly through this medical cannabis stuff. This was a large bill, so there were lots of updates to various components, not just the adult use side of things. Just for your awareness, they did expand the qualifying medical conditions for those. So those are the conditions where you can actually receive a medical card. And now it encompasses any medical condition that your healthcare practitioner will recommend cannabis for. So that really opens it up quite a bit. You don't have to have a very specific diagnosis that falls under the state's prescribed list. But you can rather, like, if your doctor thinks that, or healthcare professional thinks that it is appropriate for you, you can now get a medical card. There's also a streamlined registration process for veterans. And on the licensing front, which is obviously the majority of our conversation here today, they have changed from single use licensing, so to speak. So a medical cannabis cultivator, medical cannabis retailer, they've now condensed all of those medical cannabis licenses into a single combination business license. For those adult operators who are interested in medical cannabis, you can also apply for a medical cannabis endorsement, which is slightly different than a license. This is added on to your existing adult use cannabis license, which would allow you to conduct whatever cannabis activity your license type allows for medical cannabis usage. So if you're a cultivator, you can get a medical cannabis cultivator endorsement. There is no cap at this point in time on the number of combination business licenses that will be issued.
Generally speaking, the bill prohibits vertical integration, meaning it disallows one applicant from controlling the grow, manufacturing, and sale of adult use cannabis products. Of course, the obvious exceptions are the micro business and the meso business license types that are expressly allowed for that. Micro business allows you to grow up to 5,000 square feet of canopy, manufacture an amount of biomass equivalent to what you get from 5,000 square feet of canopy, and then allows you one retail location. The meso business gives you 15,000 square feet of canopy. Same thing with, you can manufacture products equivalent to what would come out of that canopy size, and then 3 retail locations. So just anecdotally, it seems like the meso business is the most popular license type among our client base for obvious reasons. So those are how you get around that vertical integration.
So some other just general restrictions to be aware of, and we're going to get into this here. And again, I would just want to mention that this PowerPoint will be available, so you can refer back. Although again, things change rapidly, so this is current as of today, but we will get more information, so just keep that in mind. You do have to be at least 21. You can't be employed by a state agency that's regulating the program, which makes sense. You can't be a certifying healthcare practitioner. You can't be a cop. You cannot have had a cannabis license revoked in either Minnesota, later on, or in another jurisdiction. You have to, make sure that you're compliant on all of your tax. And and not have a disqualifying criminal offense, which are largely related to felonious activities. There's a long list, and it very much requires a case-by-case basis. But there are certain offenses that you are not eligible to hold licenses if you have.
Yeah, and although it's not expressly on here, we do have a number of hemp retailer clients right now who begrudgingly stopped selling THCA hemp flower because OCM recently indicated that they consider that to be illegal under Minnesota law and federal law. So we know that there are a lot of people selling THCA products out there, making a lot of money. But if you don't want to tick off OCM, we know that the inspectors are out and sort of tagging those products as illegal.
So, and again, we will make this available for everyone, but this is a little bit of a cheat sheet for the kinds of co-licensing you can hold. So, oh, and it looks like I missed one here because the medical cannabis retailer is no longer in there. But both the micro and the meso business, you can hold cannabis event organizer licenses, but no other kind of license. Retailers, delivery service, and event organizer. If you move down to the next side, you can see the cultivation. And again, this goes back to that true party of interest and kind of alcohol. So they're keeping the processing distinct from retail. So that's what we see here. So if you are a cultivator and you want to manufacture, that's permissible. What's impermissible is a retail license. Same thing for manufacturing. You can hold cultivation, but you can't hold retail. And if you go to the next slide, you can see that, oh, maybe it's the slide after that. Anyway, the retail, you can't hold cultivation or manufacturing. We also have a couple slides in here for the hemp and medical cannabis. Something to note is if you hold the medical cannabis combo license, you can't hold any other kind of license in the state. So if you are interested in engaging in both sides of the market, it may make more sense to apply for the adult use and then apply for the endorsement for the medical cannabis aspect that you'd like to be engaged with.
We're with Vicente LLP, and you can Google us, and we'd love to answer your questions.
Yes, thanks so much for your time today, everyone.
Thank you.